Good afternoon, and thank you for attending the Florida Bar Young Lawyers Division Transition to Practice Committee webinar, a part of the How-To webinar series. This webinar is entitled, How to Transition from a Public Defender or Prosecutor Position to a Private Criminal Defense Practice. The presenter is Jason Blank of Haber Blank in Fort Lauderdale. My name is Margaret Good. I'm on the board of the Florida Bar Young Lawyers Division Board of Governors, and I am pleased to introduce to you Mr. Jason Blank. Jason is perhaps the perfect person to be presenting on this topic today as he transitioned from practice in the Broward County Public Defender's Office to establishing his own firm with his partner, Jason Haber. His practice focuses on criminal and civil litigation and trial work as well as appellate practice. He is on the Executive Council of the Criminal Law Section of the Florida Bar and is AV rated with Martin Dell Hubble, and since 2013, he has been listed as one of Florida's legal elite by Florida Trend Magazine. Jason, thanks so much for joining us today. The floor is yours.
Thanks so much, Margaret. Really, it's wonderful to be here. And I also appreciate you saying that I'm a perfect person. While my mother might agree with you, my girlfriend may not all the time, but I still think that I'm pretty perfect, and that's why I'm excited to be here. So I'm excited to be talking today on transitioning from the public practice as a public defender or state attorney or attorney general to the wonderful world of private practice in criminal defense. This isn't going to focus on civil work if you were to go to big law or even a small firm dealing with civil or family matters. This is really going to focus on some things dealing with criminal defense work. This is not going to be a presentation that's going to tell you, how to defend a case. It's not going to tell you, how to type up a stand your ground motion. These are going to be some tips and helpful hints that will hopefully allow you to build your practice some more and make things a little bit easier in the transition. So, like Margaret said, my name is Jason Blank. I do have my law firm in Fort Lauderdale here. It's Haber Blank, LLP. I was a Broward County public defender for nearly 8 years where I tried cases, I'm sure like many of you, all the way from simple possessions and DUIs all the way up to homicides and high crimes. In 2013, I left to join my firm, and then you'll see just a brief list of some of the things that I'm involved with today. I do sit on the Executive Council of the Florida Bar's Criminal Law Section, and as a representative of the Florida Bar Criminal Law Section, I want to thank the Young Lawyers Division for allowing us to work with them in putting on this presentation. I also am a board of director with the Florida Association of Criminal Defense Lawyers, and I do sit as the secretary of the Broward Association of Criminal Defense Lawyers. And I cannot deny that I am an all-around great-looking guy. I mean, look at that smile. It's pretty epic, I think. I get questions on the side of me all the time. Who is that guy? And somebody else will say, oh, that's Jason Blank. So I'm sure you all agree with me. But anyway, enough about me. We're going to talk about some things going forward and some of the things that we're going to talk about today. The first thing that we want to chat about is the retainer and how to quote. It's probably the first and one of the most daunting things that you will find when you go into private practice. We're also going to talk a little bit about certain initial pleadings and some other filings that I find a good practice, demands, and hopefully it'll help you, build your practice from the initial stages going forward. We're going to talk about some tips for setting depositions. We all know what a deposition is. We've all taken tons of them, but here's some helpful hints when you get out into private practice. We're going to talk about court appointments and, indigent for cost cases and some things that you should know about getting set up for that. We'll talk about various networking ideas and, of course, some organizations that you should join. We're definitely going to talk about some resources for you as well, and then we'll talk about some finishing thoughts on the presentation. So the first, the retainer and how to quote. The retainer is your contract with the client. You want to have every client sign a retainer no matter how big or small the fee. Whether it's a simple possession of marijuana municipal ordinance case that you might charge $500 or $750 for, or whether it's a, DUI manslaughter that you're charging $30,000 for, or maybe if you're lucky enough to have a $100,000 case walk through your door, that's great. But every single one of those clients should sign a retainer. You want to make sure that the retainer includes all of the terms of your agreement. You don't want to be going back and saying, oh, well, you know what, things change now. I'm going to need to quote you, additional money. Wait, you don't remember that we talked about how I'm going to charge for every hearing or for every filing? And we'll talk in just a couple of minutes about how to set up your quotes and how to set up your retainers, but you want to make sure that that retainer is the complete understanding of everything regarding your fee and how you are going to act in the case so that your client has no questions in his mind. You want to make sure that if there is any change to the retainer going forward, that it's in writing and it's signed by both you and the client. Remember, this is a contract. There is often litigation regarding a fee retainer or a disgruntled client who tries to come after you. You want to make sure that you've got it in writing. This is not something I can stress any less. Make sure if there's any change, it's in writing and it's signed by both of you as an acknowledgement and understanding of the change. Something you may want to understand or may want to think about, and something that we're going to talk about, is whether to charge a flat fee or an hourly fee. Often in civil cases, you hear about billable hours and people billing to the 10th of the hour at a certain rate. A lot of times in criminal, you're charging a flat fee. We're going to talk about, how to determine what that fee is, but you need to make a determination as to whether or not you want to just charge one fee, soup to nuts, start to finish, whether that case lasts 1 week, 1 month, or 1 year, or 10 years, for all the work that you're going to do. You also want to think about, are you going to offer a payment plan? A lot of our clients don't have a lot of money, especially a lot of liquid cash. They may not have the $10,000 retainer in their bank account. I can tell you that I don't think I could cut a check for $10,000 today. And I guarantee you that many of our clients can't. So are you willing to, offer a payment plan? And if so, how is that going to be broken down? That's something that you certainly want to put into the retainer. You want to make sure that whatever the terms are of that payment plan are discussed at your initial meeting with your client and are then included in that contract so that there is no dispute. That often brings us to, why the changes to the retainer should be in writing. I can't tell you how many times a client comes in here and says, what's the fee? We discuss the fee. We discuss a payment plan. We set up a down payment followed by monthly payments or bi-weekly payments or weekly payments. And sure enough, 2 or 3 payments into the plan, they come to me and go, Jason, I don't think I can make the payment this week. I'm not going to be able to come up with the $1,500 this month. I only have $1,000. Is there any way we can, lower that? My kid, just went to college, or I just lost my job, or my mom's sick, or my dog ate my homework, or whatever the excuses are that you will, if you haven't heard already, I guarantee you will hear from clients. And sometimes you can make arrangements that work for both of you. Sometimes you can't. But whatever that arrangement is changed to, you want to make sure it's in writing. And then you want to think about, will you include costs as a part of your fee? This is a very important segment that a lot of young private practice lawyers don't think about. When you're working up a case, especially as a government lawyer, you don't think twice about setting depositions, getting subpoenas served, maybe sending an investigator to take photos, or even getting photos printed. What about blow-ups for trial? What about getting copies of reports or DUI videos? Maybe getting the CAD report or the TAR report. Those things often cost money. And is that something that you want coming out of your pocket, or is that something that your client is going to pay for? Is that something that you're going to contemplate in the flat fee you quote your client? Or is that something you're going to say to your client, hey, you're going to have to pay separately, and here's how we do it? If you're not going to include it as part of your fee, are you going to take a cost deposit up front? What do I mean by that? Often what we will do is have our clients give us a separate amount of money that is specifically designated for the payment of costs. Those investigators, those large mailings, those videos, those CAD reports, the photocopying, the photographs, the hiring of an investigator, whatever it might be, serving a deposition subpoena. How about having a court reporter? They cost money. All those things cost money. So if you take a cost deposit, you then have to have a trust account. A lot of criminal defense lawyers who are in solo practice or working with small firms, they may not have trust accounts. So if you don't have a trust account, then you really can't take a cost deposit. But if you do, you should. And, cost deposits are a great way because the client understands that money is specifically designated for the work you're doing on the case. They also know that if it's not used up, they're going to get it back at the end of the day. Just remember, with a trust account comes a lot of responsibility. More lawyers get in trouble with the bar as to issues with their trust accounts than just about anything else. So you want to make sure that you know what you're doing and that you take very good care of that trust account. So let's talk a little bit more about the retainer. This is some helpful language to include in your retainer that I have developed by talking to other lawyers, reading some books, and quite frankly, looking at their retainer agreements. I've added edited and amended and changed my retainer over the years, but these are some things that I think are really important to include as a criminal defense lawyer. Firstly, you want to put a clause in there that says, you agree this is a reasonable fee for the handling of your case. A client, when they just get out of jail, will pretty much pay anything a lot of the time just to have a lawyer on their side. They're going to think that you are the cream of the crop, and they're going to pay you tens of thousands of dollars to go to court for them. Then 2 weeks later, they're going to talk to somebody who said, well, my lawyer did it for $500. And then they're going to start talking about, well, how come you charged me so much? You need to be able to stick by your fee, and you want to make sure that that client understands that it is a reasonable fee for the handling of his case. Because we try not to quote unreasonable fees ever. Well, we just don't quote unreasonable fees. But we want to make sure that in that contract, they are stating that they agree that the amount they have said they would pay is a reasonable fee. You also want to include language about how they understand and acknowledge that their payment of the fees does not guarantee any specific result. You know, we all know we can't guarantee exactly what the judge will do at sentencing. We don't know if we can win a trial. We can't guarantee that motion to suppress is going to get granted. We don't know if the state's going to be as nice as we want them to be in negotiating that youthful offender sentence. So we want to make sure that a client has no questions that you are not guaranteeing them anything. You cannot promise a result. You should not be promising results, and you want to make sure that they know that from the start. You understand that the fees which you pay at this firm are separate and apart from any court costs and fines that you may incur as a result of the resolution of your case. I cannot tell you how many times my client at the end of the case goes, so you paid that $293 fine that they gave me for pleading out my misdemeanor, right? I go, no, you have to pay that to the clerk of the courts. They have to make sure that the fees, fines, costs, all of that is their responsibility. And again, this is more of a, you want to make sure they have full understanding from the outset than it is anything that could come back to bite you. There's no question that they're responsible for it, but you just want to make sure that they know. You acknowledge and agree that failure to make any of the payments towards the flat fee in accordance with the agreed upon structure is grounds for immediate withdrawal from representation in this matter. We don't work for free, folks. Clients have to understand that, and they do. Most do. But you want to make sure that they understand that they're agreeing off the bat. If they don't make that payment, you're going to get off. Your time is money. And when they get that motion to withdraw, you don't want there to be any question from them about, oh, you told me you'd give me leeway. You told me, I didn't know. No, they knew. They knew that if they didn't make payment, you'd be withdrawing, and the courts understand that too. Another little helpful hint, usually if you're going to withdraw off a case because of a lack of payment, before you file the motion, type it up and just send it to the client. You'd be amazed at how quickly they respond and drop off a check the next day. So let's talk about quoting a fee. The best piece of advice for how to quote a fee that I got is this. How much are you willing to do the case for? No two lawyers will quote the same way or the same amount of money for any given case. The question ultimately to you is, how much are you willing to take? What is the lowest you're willing to go, not the client? What is it worth to you to spend the time necessary to properly defend this case? And once you make that determination in your mind, then you can make a determination as to where you're willing to go with the quote. Of course, we all want to get the most money possible for any case that we have, as long as it's a reasonable amount, but not everybody can pay those fees that we want. So the question for you is going to be, how much are you willing to do the case for? And once you've made that determination, you can then quote a fee. But remember, once you quote a fee, stay true to your word. This is not, something to waver and vacillate on. This is not something to go back and forth with. You need to be confident in the fee that you quote. Know that you're worth the money that you're quoting. And if you question your value and you don't think you're worth the amount of money that you're quoting for that fee, maybe you need to rethink how much you're quoting. Not every lawyer is worth $25,000 for a misdemeanor. Some are, some aren't. Some can get that, some can't. You have to make the determination as to where you fall on that list. Don't steal clients. Remember, the criminal defense bar is a very tight-knit community. They're going to talk. We are going to know each other, And we, more than most bars, are there to help each other in times of need, whether it be personally, whether it be coverage, whether it be just a question on a motion. You do not want to get in a situation where nobody wants to be your friend. It's just not ethical, it's just not right, and it's not how criminal defense lawyers work. Now, there will be times when clients who have already hired a lawyer will come into your office because they're not pleased with that lawyer. Don't get me wrong. Not every client is good for every lawyer. And there's nothing wrong with a client who says, I don't want this lawyer anymore, I want to hire you. But I would suggest, and I would argue, do not steal clients from other lawyers. It's not a good practice. It's the fastest way to isolate yourself in the community. You also want to think about how many depositions are needed. You know, that often is something that you're going to want to contemplate in how to quote a fee. How much work, how much time am I going to need to put into this? Is there a lot of investigation that's going to be necessary? Am I going to spend hours and hours on the phone dealing with school boards and family members in Uganda or Lithuania or somewhere in South America for mitigation? How much time do you anticipate spending on the case? Are you going to be going to court 3 times a month? Are you going to be filing motion after motion after motion? Will there be 10 motions in limine and 2 motions to suppress, maybe a stand your ground motion? Is this a case that's going to go to trial, or is this something that you may be able to resolve? These are the types of things you want to think about when you're determining how to quote. Don't forget to do a conflict check. We have all represented a lot of people, and especially if you are going to be working with a firm, you'd be amazed at how many times conflicts pop up. And if you're not sure if you have a conflict, if you're not sure that a representation of someone or a prosecution of somebody in the past has created a conflict for you in a potential client that's come into your office, that's okay. The bar can help you out. Not a lot of people know that, but the bar can help you out. This is the Bar Ethics Hotline. Save it. Don't be afraid to use it. When I was a public defender, I had this number locked into my cell phone, and so many times when I thought there might be some sort of ethical conundrum or some conflict come up, I'd ask the judges to step into the jury room, and I'd call the number. The guys and girls that are on the ethics hotline are phenomenal. They will give you a confidential evaluation as to your situation. They'll advise you as to the ethics rules that apply. And then if you ask for it, they'll give you a confirmation number for the call that you can save and put in your records just in case an issue comes up in the future. So save that number, use it, call them. I've called them tons of times. They're always wonderful and very helpful. So now we're going to talk a little bit about initial pleadings and other filings. Things that you are going to want to file as a private attorney. Notice of appearance, written plea of not guilty, and a demand for jury trial. The demand for discovery we're going to talk a little bit about. A waiver of appearance. And an authorization to represent and a plea in absentia, but that's only for misdemeanor cases. You may have heard about these. You may use them in your circuit. When I was a public defender, we did not do written pleas of not guilty. We did not do authorizations and plea in absentias, really. And our secretaries handled filing of all these things. So we didn't have our hands on it, and I was a little lost when I first went out. This is an example of some of the language that I have in my written plea of not guilty, my notice of appearance, and we're going to go through this with all of these documents, and I've just included some language from mine. My contact information I'm going to give out later. You can feel free to reach out to me, and I'll be happy to send you the pleadings that I use. But within the notice of appearance of the written plea of not guilty, and a lot of circuits through e-filing, they will have a designation where you could file all of these things together in one document. It's a good practice. It keeps it short and limits on the amount of work you need to do. But you want to make sure that the language is correct and appropriate. And if you are going to file that written plea of not guilty, make sure that everybody's aware that not only can you file that, but your client has a right to file that and does not have to appear for arraignment unless there's a bond status, but we all know about that. The demand for discovery. So here are some pertinent parts, and again, I'm sorry about the size of the font, but I wanted to fit it all in here. I pulled out some parts of my demand for discovery. My demand is about 4 pages long. A lot of people will just, in their written plea of not guilty put a one-liner that says, I hereby demand discovery pursuant to Florida Rule of Criminal Procedure 3.220. I don't think that is sufficient so that you can then go back and attack it. I like listing out a lot of specifics in my demand of things that I expect the government to give me, as part of the discovery process. Some things that you may not think about, but that I believe are pertinent today deals with the cell phones, whether it be starfish, whether it be cell site towers or triggerfish, whether it be just the state subpoenas to the common carriers, the cell phone carriers. You want to list out the specifics in your demand so that if they pop up later, you can, move for sanctions, move for that state charge continuance, move to strike some of the evidence. Because you can then go back and say, Judge, I specifically put this in there. They knew about it. There's no question about it. Now, let's be honest. The government does not go and read every page of this. They can't. They're overworked and overburdened. The state attorneys in Broward County are slammed with a ridiculously high caseload. But if the issue comes up, you can always go to your state attorney and say, hey, take a look at my demand. I actually already asked for this. You should have given it to me. A lot of times they'll say, yeah, I see that. I'll just go ahead and take the state continuance that you have time to do that. So there's a lot of cooperation in that regard. But that's one of the important parts about including specifics. Here's another very important part that I think a lot of state attorneys sometimes forget and don't understand or don't, focus on, is that they have to turn over all that impeachment, motive, and bias information to you as well in the demand for discovery. And I cited some of the general cases with the United States Supreme Court there that talk about it. And this language is great to put in there, so when in deposition a witness or a victim says, oh, well, I did X, Y, or Z, you can go back to the state and say, number one, did you know about this? Number two, why didn't you tell me if you did? And then the second paragraph at the bottom, I find to apply a lot with domestic violence cases. And that deals with victims applying for non-immigrant visas as a crime victim. It is a way for people who are here illegally or even here, where their green card may be about to expire to stay longer. And that's a great piece of information that you can use for impeachment at trial and to try to contradict or attack a victim in a case. So that's something that I ask for up front, and I force my state to go look for it and contact the, immigration services to see if one has been filed. So waiver of appearance. I'm not sure, I didn't know this for the longest time when I was a public defender until I did, so probably a couple months, maybe a few more than a couple. Your client does not have to appear at all these pretrial conferences. Now, some judges get sneaky and they set it for trial instead of a calendar call or a sounding or a status conference, and they say, well, this doesn't apply to them. But most judges will set a case for a pretrial conference or a calendar call before setting it for trial. Your client doesn't have to be there unless otherwise ordered by the judge or unless you need them there. So this is a waiver of appearance that you're going to want to file. The rules allow for it, case law allows for it, but you want to make sure that it is notarized. If it's not notarized, it's not valid. And some people forget about that. So it doesn't have to be anything fancy, just a few lines of language there. Have the client sign it, make sure it's notarized. Of course, you'll put your signature block underneath, and then you'll e-file it appropriately. But a waiver of appearance is something that I have every client sign the very first day they come in. When they sign their retainer, they sign their retainer, they sign a waiver of appearance, and if it's a misdemeanor, they also sign that plea in absentia that we're going to go over in a minute. I have them sign it right off the bat, and I file it, mostly so it's just there. Even if your client wants to go to court every week, they may get into a situation where they can't. And if you have a stickler of a judge, at least you could say, Judge, there's a waiver of appearance in the file, so he doesn't have to be here. I know you wanted to see his smiling face, but he doesn't have to be here, Judge. I'm sorry to disappoint you. We filed the appropriate paperwork. If you don't file the appropriate paperwork, that judge could issue a capias. At the very least, this will allow a reset of your hearing or a good appellate issue if your judge does issue a capias at a time where your client doesn't appear. So, I would suggest definitely filing one of these in every case, even if your client wants to go all the time. Here's an affidavit of the defendant and the authorization for the plea, meaning that they are authorizing you to enter a plea on their behalf, and of course their waiver of a personal appearance for the plea. This is just a portion of it. This is not all of it because I couldn't fit it, but the important part is in the beginning, these first few paragraphs. The client needs to specify that they are waiving their appearance and furthermore, that they are authorizing their attorneys to perform any and all negotiations as well as resolution of the case. They waive speedy trial and all the other waivers that are necessary, to allow the resolution to go forward. It's important that you know that when they enter a resolution on a case on behalf of a client, if it's a withhold, you don't have to have fingerprints. If there's a possibility of an adjudication, get your client's fingerprints ahead of time and bring them to court with you. A lot of judges will say, oh, I can't take this because it's going to be an adjudication, time served. You say, Judge, look, I don't want to come back. Here are his fingerprints. We already got them taken. And I would suggest having them go down to the police department locally, have them taken there. They will have one of the fingerprint cards with the department head on it so that there's no question by the judge that they're real. They'll sign off on it. And make sure you go over with your client, not just the fact that you're going to resolve their case on their behalf, but all the rights that they're going to waive just like they were in court. I actually have a copy of a plea form that we use here in Broward County in my office. And when they're going through and signing the authorization for the plea and the plea in absentia, even though the rights are contained in that pleading and the client can look at it, I have them look at the plea form with me, just like they'd sign in court. And I explain to them, look, this is what you would do in court. You'd initial all these lines, you'd sign here, we'd go through all these rights, the judge would go through all these rights with you, and see, it's the same thing in this document. Clients sometimes can be leery about allowing you to take care of their case without them there. Some clients love it, and they go, I don't ever want to go to court. But it's a good way to show them that, hey, look, I'm not putting anything different or special in this document. I'm just saying you're allowing me to take care of it for you, and you'll see all the rights you'd give up in court are the same ones that you see here. It's a great way to resolve a misdemeanor quickly without having your client to take off work or miss school. A lot of clients will appreciate if you do things like filing the authorization for plea in absentia, filing a waiver of appearance, because although clients are often scared with their cases, they also find it to be a hassle to go to court that often. So let's talk now a little bit about some tips for setting depositions. When I was a public defender, I had a caseload of anywhere from 110 to 300 cases at any given time, depending on what division I was in. I was setting depositions every day. I had depositions set in the morning, I had depositions set in the afternoon. Might be a little less if you're working in a smaller jurisdiction, but we were busy here. Very, very busy. And we didn't really coordinate with the state too much. The state just knew we were going to set depositions all the time. They were just there. If we had a co-defendant counsel, a lot of times the private lawyer would come to me as the public defender and say, hey, why don't you just go ahead and set depositions? Just notice me. Little different when you're in private practice. Now you're on the other side. The state's busy. They're not seeing you every day. They may not know you. If you're in a jurisdiction that you haven't practiced in previously, or maybe they're new and you haven't been in a misdemeanor division in 5 years because you've been up in a felony division trying carjackings and homicides, you need to coordinate with them to make sure that they're going to be around, that they're going to be okay with the depositions, and especially with co-defendants counsel as well. Lawyers work together. And you have an obligation to speak with them and coordinate with them the setting of depositions in a case where there are multiple lawyers. One other thing I will tell you is to look at the rules, because you want to make sure that the location of the deposition is acceptable to all parties. The rule states that the deposition must be held in the court in which the case is pending, or another location if it's agreed upon by the parties. So if you're going to hold it in your office, you need to speak with the state and make sure that that's okay with them. Otherwise, you'll probably have to reserve a room in the courthouse. All the circuits and most of the courthouses have designated rooms through court administration that you can reserve. There's no cost to it really, and that way you can take your deposition there. A lot of times the state won't care, especially for law enforcement depositions. They don't go half the time anyway, so they'll say, I don't care. As long as the cops are okay with it, you just do it there. So that's something to keep in mind. I think it's important to learn the witness fees associated with each law enforcement agency. Yeah, we got to pay the cops to come in for deposition. Didn't know that, did you? As a public defender, and obviously as a state attorney you didn't have to worry about that, but as a public defender we didn't worry about it because our clients were indigent. But if your client's not indigent, you have to actually cut a check and send it in with the subpoena to the cop if you're going to bring them in. Otherwise, they won't come in for deposition. And that's by rule. Each law enforcement agency has a different witness fee. So you're going to want to maybe call around to some of the more common law enforcement agencies in the area. Maybe create a list. That's what I did. I had my secretary call around, and we have a list of all of the witness fees for each law enforcement agency in the area, so that whenever we set the deposition, we just know exactly how much of a check to attach to it. Sometimes the cops won't cash the checks. Sometimes they'll bring them back. Other times they'll certainly take them with a smile. You want to make sure that your subpoenas include all necessary language. I'm not going to include that here because, quite frankly, they're just long. But you want to make sure it includes the language about people who may need accommodations and the phone number to call to get that taken care of. Your failure to include that language could render your subpoena invalid. So we don't want to do that because time is money. And when you're in private practice, having to redo things can not only get monotonous, but it does waste time, and you don't want to be doing that. You want to find out if the witness liaison will accept service through the mail for law enforcement depositions. This was a tip that a friend of mine gave me when I first came out. One of my first cases was a first-time DUI. I was setting a couple of depots, and I was talking about where to serve the cops. And my buddy said, just send a page to the liaison. I said, what? He said, yeah, brilliant idea. So you can take the deposition subpoenas, include with it a cover letter, and what I do is I type up a separate page that just says and then I leave a blank for the witness liaison's name, witness liaison to whatever agency, acknowledge the receipt and of the following subpoenas for deposition. And then underneath that I will list the officer's name, the time and date of his deposition. And at the bottom, I'll put a signature line for the witness liaison. They will initial each of the depots, and then they'll sign at the bottom. It's served. That constitutes service. And you put in their language saying, and I agree that this constitutes service for these officers. The witness liaison will accept that, sign the form, and mail it back to you. And then all of a sudden, you don't have to worry about process servers for cops. It's simple. The witness liaisons like it because it's less trouble for them. And actually, you can call them, just call the witness liaison and say, is this something that you'll do? Usually they say yes. If it's a court-appointed or an indigent for cost case, you want to remember to include a copy of the appointment or indigency order with each subpoena to be served. This is a mistake that we make all the time, slip of the mind. If you're sending out 5 or 6 different depositions, subpoena depositions to an agency, you can't just include one order of indigency or one order of court appointment. You have to include one for each subpoena. So you want to do the subpoena, and then on the back of it, staple a copy of the order if it's a court-appointed or indigent for cost case. That's in lieu of the check that you would have to otherwise send for a witness fee. So that actually brings us nicely into talking a little bit about court appointments and indigent for cost cases. These deposition tips should be really helpful. If you have any other questions about depositions, feel free to reach out to me. So court appointments and indigent for cost. Each circuit will have a different process for getting on what we call here the wheel to be court-appointed cases. The wheel is the list of special public defenders that will be chosen when the Office of Regional Counsel has a conflict. Usually involves filling out an application and having enough trials, CLE, years of practice, things like that. The qualifications are different in each circuit, and the qualifications are different for each level of appointment that you're looking to take. A juvenile appointment requires different things than a first-degree felony appointment, as well as the misdemeanors or second degrees. So you're going to want to look at the differences in the appointments on the circuit for which you're trying to get on the wheel, or in the circuit for which you're trying to get on the wheel. You could probably go to the website for the circuit. That's where ours is found, down here in the 17th, and there's a pretty simple cut and dry process. No big deal. If you've been a public defender or a state attorney for 3 or 4 or 5 years, you're going to be fine. You're going to have enough trials and CLEs, I guarantee it. The Justice Administrative Commission, or JAC, is the one that oversees and pays lawyers for their work on court-appointed cases. Their procedures are very specific, very specified. You have to follow them to a T or they won't pay you. They're pretty reasonable when you talk to them, even though the courts are making the determination ultimately as to what kind of money you're going to get from the JAC. As far as costs and as far as billable hour cases, there are set rates for handling court-appointed cases, and those can be found on the JAC website. The JAC also pays for reimbursements for due process costs, where clients have been declared indigent for costs. We're going to talk about indigency again. We're not going to get too much into it, but if your client is indigent for costs, meaning that they would qualify essentially for a public defender, but have been able to come up with enough money to hire you as an attorney, the JEC will be directed to pay for those due process costs. There's a whole process for that and procedure for that. You have to file motions for each cost that you're seeking to be reimbursed for or you're seeking for them to cover, but those procedures are laid out all on the website. Also, you want to make sure that you sign contracts with the JEC prior to being eligible for payment on court-appointed cases and for JEC indigent for cost cases. You will not get paid, and they are quick to let the court know that you do not have a valid contract if you don't sign one. They're easy contracts to sign and easy to find. It's really not confusing at all. This is the website. You're going to go to www.justiceadmin.org, and then what you're going to see here, once you go there, this is the home page. The home page for the JEC, and the home page is great. Up here, you'll see My Access Login. You'll be able to get a login account once you get started, and then over here on the left, you're going to see the left bottom, there are tabs, this whole listing of tabs. Court-appointed IFC is a great place to start. You're going to click on that, and then it'll give you links for the contracts and all the other things that are necessary. Let's talk about networking ideas. People hire lawyers that they know. People hire lawyers that they know. That is the best piece of advice I can tell you of how to set your mindset when you're talking about networking. How do we find clients, right? Everybody wants to know, how do I find clients? Because people hire lawyers that they know, you want to start with people that you know and tell them you're a lawyer. Tell them that you're out in private practice. Tell them what you do. Because even though they may not be the type of person that gets arrested, I guarantee you they know someone who is. You want to network across many areas. It's one of the best ways to get business. You don't just want to say, oh, I'm only going to advertise online, or I'm only going to do direct mailing. There are plenty of ways to advertise, but just like you want to, what's the term when they talk about financials? Diversify your portfolio. You want to do the same thing when you're talking about networking. Now, of course, the local bar association happy hours are great, but where else can you network? Plenty of places. You can network with your college and your law school alumni associations. But don't just go to an event and say, oh, hey, I'm a lawyer, pass out your card. You need to be known. You want people in your community to know who you are. You want them to trust you. You want them to know that you appreciate the fact that they may be sending you business. Check out local social organizations. Maybe there are some charitable organizations that you could join as well, or your temple or church organizations. It really depends on what your background is. You don't have to spend a lot of money to network. There are plenty of different ways that you can network. A lot of people think that networking and advertising, you have to have a separate budget because, you see billboards up there. Have you been injured? Do you need an attorney? Divorced? We only handle men. Whatever it is, you don't have to spend a lot of money. That's one way to network and that's one way to advertise. But there are things you can do to try to get clients that are not going to cost you an arm and a leg and aren't going to take a whole lot of money out of that fee that you're going to get. I love sending letters to friends and former clients. If I have a friend or somebody I know just got a new job, I'll send them a letter. Maybe their job is an area of law that we handle. Now, in my firm, we handle areas beyond criminal defense work. My law partner handles family law and real estate, commercial litigation. My associates do real estate and transactional and family law, administrative law. So it's good for me to reach out to people who may be in an area different than mine, who also may not be the type of person to get arrested, but maybe they do real estate. Maybe they're a realtor. And I'm going to send them a letter saying, hey, congratulations on that new job. I'm so proud of you. I remember when we were in law school, or when I was in law school, and we had that great conversation at the bar right after I failed my Civ Pro exam. I didn't really fail the exam, but anyway. And I'm going to say, by the way, don't forget, my law firm handles real estate matters. So if you ever need anything, let us know. I encourage you to go check out our website to see everything that we do and to learn a little bit more about us. A simple letter like that is something that can get you one case or more. But all it takes is one case to help out with that monthly rent, or that one case to help out with, paying for your secretary. every dollar that comes in helps, and you never know where that next dollar is going to come from. Or maybe they're not going to bring in that real estate case. Maybe they'll say, hey, you know what, I really liked him because he sent me that letter. I haven't seen him in a year and a half, but my neighbor just called me and she said that she got arrested for a DUI. I gave her your name, so I hope that doesn't hurt. Everything helps. You get that name out there, you keep those connections, you will generate business. Former clients are a great way to do that too, because you want to make sure that that client who was happy with your services, because of course you're going to quote them a reasonable fee, you're going to treat them well, and you're going to do the best you can to put them in the best position possible. They may not be a repeat offender. Maybe they are, and that's great. It's like a steady stream of business. But if they're not a repeat offender, you want them to say to their friends, wherever they are, my lawyer was great and you should hire him too. So you want to keep that in touch with those former clients and make sure that they're happy. Follow up with people you meet at events. If you do go to that local bar association happy hour, or you do go to that networking event, or you happen to go to your college alumni association basketball watch party, make sure to follow up with the people you meet. If you get a business card, email them the next morning. Hey, it was great to see you. It takes all of 2 minutes, but it can make a lasting impression that ultimately will lead to business. Always carry business cards wherever you go. You never know when you're going to run into somebody who says, hey, let me get one of your cards. Or, oh, you're a lawyer? What type of law do you practice? Oh, my cousin's in a little bit of trouble. He was arrested last week for trafficking. Maybe he can give you a call, or maybe you can go see him in jail. You never know. But if you don't have that card on you, that person's not going to be able to get in touch with you. So always carry business cards wherever you go, even if you think it's silly. So here are some suggestions of organizations that you may want to join. And I would even argue organizations that you should join. You want to join the Florida Bar's criminal law section if you're not already a member. If you are a lawyer that's been practicing less than 10 years, the Florida Bar Criminal Law Section is offering free first-year section dues to those lawyers who agree to sit on one of our committees. It's a great organization because the Florida Bar Criminal Law Section is the only one which includes criminal defense lawyers, prosecutors, judges, and professors all under one umbrella. We all work together to further the criminal law practice and criminal justice system under the bar's umbrella, and it's a great section to be a part of. We are developing and growing and trying to get more engaged, so we're looking for some good membership, and it's a great organization to start with. It's also a good way to network with other prosecutors who you may deal with and judges that you may appear in front of. You definitely want to join the Florida Bar Young Lawyers Division. The Young Lawyers Division has phenomenal resources for young lawyers, great networking opportunities, and they're always out there to help you. It's a great way to get involved with the bar and to make sure that you know who your friends are around you, because we all need the friends that surround us to make sure we don't fall down in the tough times when you're first going to private practice. It can be daunting, it can be scary, and a lot of the members of the Florida Bar Young Lawyers Division have already gone through it, whether it is in the civil or criminal world, so they're going to be there to make sure to keep your head high. You definitely want to join the Florida Association of Criminal Defense Lawyers. It is the largest organization of criminal defense lawyers around. We are a force here in the state of Florida. We do have a strong voice up in the Capitol building in Tallahassee, and we often fight to make sure that the laws that are going through the halls of justice, if you will, are benefiting our clients. You also want to join your local FACDL chapter. Here we call it the Broward Association of Criminal Defense Lawyers. Down in Miami, it's FACDL Miami. So you want to look for your local chapter of FACDL and join it. FACDL statewide has chapter representatives from all over the state, so you will have that direct link to this statewide organization by joining your local chapter. Join your local bar association and get involved. You will find that you will get many criminal clients from the family law attorneys, or the real estate attorneys, or the corporate attorneys, the business law attorneys, who are active in the local bar association. They love networking. They will say, hey, I'll definitely send you a case. By the way, I do family law, so send me whatever you got if you have anything come across your plate. Those relationships that you can get from other active attorneys will pay dividends. And definitely join social and charitable organizations, not just as a way to network for yourself, but it is a great way to build your reputation in the community, get yourself positive press maybe if you go to an event, and to let your clients know that you're just not some guy who's trying to take their money. Clients like knowing that you're involved. They like seeing that you're active in the community, and I guarantee you, a client who looks at you when you are active in a social or charitable organization, who sees your face in the paper or in a magazine that comes across their desk, or maybe their dentist's waiting table or wherever it is more likely to hire you than some guy they've never met before and they just got a name from a friend. So those small things of being involved in those organizations, especially on the social and charitable level, will also pay out, and they will help you in locking up those clients who may be talking to other lawyers. The National Association of Criminal Defense Lawyers is also a phenomenal organization. They focus on the big scale. They're dealing with national issues, wide-scale issues such as fingerprint analysis. They just had a giant campaign for federal clemency issues, seeking pro bono attorneys to help with that. They're a great organization to be involved with. And if you do have a federal practice, you certainly want to join the Federal Bar Association. I should probably also put out there, I guess, that a lot of the information I've given you today really just deals with state practice. My practice is state-based. I don't do very much federal work, although I am barred federally. It's a whole different animal in the federal courts, but it's a great animal as well. It's just a completely different process, and I highly recommend that you recognize the difference now, so that if a client comes in dealing with a federal case, I'm not saying turn them away, but you definitely want to get yourself set up with someone who knows what they're doing when they walk into federal court. Let's talk a little bit about resources for you. You're going out, you've left the government, you're now going to open up your own practice. You're in a situation where you don't really know if you're doing everything right. You may want to check into some things. Maybe you want to make sure you're doing it the best you can. The Florida Bar has a phenomenal resource for you in the PRI. They are able to give you all types of tips and suggestions on how to run a practice, how to run your office. It's something that's very tough to do because coming from the government, it's all set up. You know, it's a well-oiled machine, or so it should be. So when you come out to the real world, so to speak, and you're hanging your shingle, opening your practice, there are a lot of things you might not think about, and what you don't want to do is get yourself stuck where you ultimately are in a position of potentially getting in trouble or doing something wrong that could jeopardize your practice. This is your livelihood. We all know that. You want to make sure you do it right and to the best of your ability, just like you would for your clients in court. So the PRI is a phenomenal resource for you. Some other resources, that you may want to reach out to, both for clients and just for information. The lawyer referral service through the Florida Bar is great. You could sign up, and they will actually have people calling them saying, I was arrested, or I want to get this expunged, or, how do I deal with this? I need a lawyer, and I don't have a whole lot of money, or I just need a lawyer. I'm from New Jersey, and I've got this warrant down in Florida. How do I find a lawyer? They'll call the bar, or they'll call the local lawyer referral service. The jurisdictions that have local referral services don't go through the Florida Bar. They go through the local bar. So we here down in Broward, we have our own lawyer referral service that I'm a member of. I've gotten great cases from that. It's an amazing resource that not a lot of people know about and utilize, especially in the criminal world. A lot of people will do it and sign up for it for family or real estate or commercial or condo, but they don't think about it for criminal law referrals. The best part about it, it may cost you $150 or $250 or $300 to sign up for the program for the year, but if you get one case, just one case that's referred by them that pays out, you've covered your costs and made some. I actually have a client who originally came to me through the lawyer referral service in Broward, and from that client, I've had about 4 cases. I've had 2 criminal cases, and then they referred friends of theirs over, and I had another 2 cases come that way. So that has just made it all worth it for the years that I've been signed up with them. And you're going to have to go to each individual circuit, determine whether or not you have a local referral service, and if you do, the requirements and the costs are different through each of those. The Florida Bar Criminal Law Section's website is a great one. We have a lot of resources on there. I highly recommend you going to check that out as well. You can sign up on the website as a section member. or you could just do that when you get your bar dues. FACDL, also phenomenal organization. And once you're a part of FACDL, at that point in time, you'll have access to forums and information. There's a huge listserv of the defense attorneys around the state that are very active in various legal issues and office issues and things of that nature. Also, you have NACDL. The Young Lawyers Division is a great website, to know what's going on in the bar and how you can get involved in the networking that they offer. You, of course, want to talk to your friends and colleagues in your circuit because they're going to be the ones who are best able to tell you how certain judges deal with certain things, what their practices are for how they run their office and how they run their practice, and the judges. Talk to the judges. Let the judges know your face. So when you walk into that courtroom, even if it's on a difficult case, they know that you're out in private practice. You're not just a PD to them anymore. You're now in private practice, and they're going to understand that. Let's be honest. A lot of times, private practitioners get benefits that PDs don't, especially when it comes to scheduling and things like that, because PDs are in the courtroom all the time, every day. Their office might be across the street or might be in the courthouse, so it's a little bit easier for them to go back and forth. If the judge knows you're in private practice, you're just starting out, they may help you out a little bit. Not necessarily in favorable rulings, but at least with scheduling, if nothing else. So now I have some finishing thoughts. Your reputation can make or break you. You want to keep that in mind. We all heard in law school that your reputation and the way people look at you starts from the minute you enter law school until now. Or from the minute you park your car in the garage of the courthouse, people are watching you. Potential jurors are watching you, so watch how you carry yourself. It's true. If your reputation is one that is not very good, you're not going to get the help from your colleagues and from the judges that other lawyers might get. You won't get that benefit of the doubt, and I'll guarantee you that potential clients will go elsewhere, especially if they're talking to another lawyer. You want them to choose you over the other lawyer, not the other lawyer over you. There are a million resources out there to help you succeed as a private practitioner in the criminal defense world. Use them. Go to the websites. Use the PRI. Call the numbers. Read the books. They're out there. If you have a question, somebody is there to answer it. If you're not sure how something is done, there is some information out there to help you figure it out. Don't be silly. Go and read the websites, do the research, take the time to make sure you're doing it right. And don't be afraid to admit that you don't know something. Just because you've been a lawyer for 2 or 5 or 10 years doesn't mean that you know everything. I don't know everything. I've been practicing for just about 10 years now, and I got to tell you, I'm learning stuff all the time, especially with private practice. I'm still calling my friends who have been practicing longer than I have, especially in private practice, going, how do I do this? Do I send the subpoena to the person? Do I have to attach the subpoena to this document? How do I get a CAD report from this agency? Who do I call? These are things that you just have to understand. Everybody knows you may not know, and you can't be afraid to ask. Running an effective and proper business is just as important to your clients as is your performance in court. When clients come into your office, they want to see that things are running well. They want to know that when they call you and say, how much money do I owe? You're not going, I think it's like $3,500, I don't know. And they say, well, but I made a $3,000 payment just 2 days ago. You want to show them that you are a professional at all levels of your practice. And it's important because that is what builds your reputation. And as we said earlier, your reputation can make or break you. You have to decide what type of lawyer you want to be. Are you the lawyer that just wants to be a street lawyer, who wants to walk up and down the street just taking whatever client they can find on the street? There's nothing wrong with that. A lot of guys make a decent living on volume. Or do you want to be an ivory tower lawyer, the criminal defense guy who's in the penthouse of the tallest building in town and charging really, really high fees but taking 2 cases a year? There are guys who do that too. Somewhere between the two, you will find what type of lawyer you want to be. And once you make that determination, everything else will fall in line. And let me also just say this. Please, don't forget, enjoy your job. Enjoy your job. Being a government lawyer is a thankless job. Often so is being a private criminal practitioner. It's tough, but we are all fighting for the Constitution and for our clients and for their rights. And you have to get up in the morning and enjoy what you do. If you don't, then don't do it. Because the enjoyment of your job will reflect on your clients and will reflect in the job that you do for your clients going forward. So with that, I say thank you. I can be reached at any point in time. Here's my address and my phone number, as well as our website and my email. And you can feel free to reach out to me if you have any questions or want any of the resources that I have. Please, anytime, I'm happy to help. And best of luck to you in the practice of law and private practice. Make sure to do our profession proud and do a good job out there. Thanks so much, everybody. I hope you enjoyed it.
Jason, thanks so much for that great presentation. On behalf of the Florida Bar Young Lawyers Division Board of Governors, I thank you all for attending today's program and look forward to seeing you at future CLE webinars.